Dear students, in today's lecture, I wish to discuss the waste management law, the domestic one, of course, and especially with special reference to hazardous wastes. Now, the laws that we have relating to waste management in our country, it all emerges out of an Environment Protection Act of 1986 because it was the umbrella legislation which empowered the central government to adopt, enact, notify rules, regulations, notifications from time to time with respect to several facets dealing with environmental related issues. Now, as we all know that we are as a developing country been undergoing several changes in our socio-economic pattern, in our industrial pattern, and because of this industrial development, we are also giving birth to pollutions. And at the same point of time, when we talk about pollution, we have discussed about water pollution, air pollution, right? Noise pollution. But waste is something which is again a big challenge for us because not just the industries, I believe even in our day-to-day life, our domestic waste generation is something which is also very significant and significantly, a matter of great concern, especially the municipal solid wastes. And when it comes to these wastes, they are of several types and categories, as you all know. Biodegradable, degradable is just two categories, but with respect to the nature of a particular kind of waste or the properties that particular waste bears, we have, say, hazardous wastes, we have municipal solid waste, we have waste generating from biomedical instruments, and etc. etc. We have also wastes which are exclusively from plastics or use of plastics. We have batteries wastes also at the same point of time. So on and so forth. There are several such wastes, which in fact is a matter of grave concern for not just India, I believe it is for the entire world, but especially when it comes to India. The Bhopal Holocaust was something which kind of was an eye opener because more than 3,000 people died and 2 lakh plus people got affected because of, methyl isocyanide gas, right? And Bhopal gas tragedy was something which didn't affect not just the, which not only affected the uh, current generation, so back then it was the present generation, but also the future generation. So it was very much intergenerational in nature. The same goes with Russia, where Chernobyl was something, the Chernobyl incident, nuclear plant, that also was a major concern. The Love Canal incident of United States, I believe I have mentioned about it. If you refer to the Love Canal incident of 1978 in United States, where the resident of a particular area was evacuated because the U.S. government, in fact, realized that there was, certain hazardous waste which was dumped, and it was the people of color who were residing, and there was another racial side of waste management which in fact you will come across if you refer to Love Canal incident. Then there were several incidents like that in say Minamata in Japan, the mercury, where the barrels of vinegars in a pickle factory, which played a very significant role in Italy. It was the Sevesco incident of Italy. And Minamata, once again, it was with respect to methyl mercury poisoning in Minamata, Japan. It was somewhere between 1956 to 1980. That's what it is. So all these industrial releases became a matter of great concern. In fact, once again in 1979, the Three Mile Island nuclear power station of United States, and of course Chernobyl, as I mentioned a while back, of Russia, was also a representation of what kind of waste we have been like kind of facing up lately in our with this evolution of human industry as well as development. All these new forms of waste, in fact, generated. So this became a very matter of great concern because. With this evolution and development of industries, new forms of waste also started getting generated from these establishments, and at the same point of time it was also it became a matter of great concern for the lawmakers to consider and think about all these things. So in this lecture I'll deal with these laws relating to hazardous waste management. Now, internationally, we know there were several such initiatives which were taken, and I believe I have mentioned about it. Besides the Stockholm Conference and Rio Conference, with respect to waste management, especially the transboundary, movement of wastes, there was something called Basel Convention, which also came. Now, since this discussion is only on domestic, I just am giving you a very brief background of the same. Now, this Basel Convention, which was adopted, but unfortunately, this Basel Convention was not sufficient enough. I'll tell you why. Because Basel Convention was adopted because it was primarily the African countries which were kind of facing transboundary disposal of hazardous waste, especially coming from the Western countries to their territories, and they were getting it dumped over there. Now, what happened is that it became a major concern for the African countries, and they in fact mooted it. And in the international forum, they asked for an absolute ban of these transboundary movement of hazardous waste. In fact, they wanted to amend the Basel Convention with an amendment, commonly known as the Ban Amendment. But unfortunately, the lobby from the side of the Western countries were very much strong, and United States was also there. It was kind of going against the interest of many of these industrialized nations. So it didn't pass muster, and that is the reason because of which the Basel Convention's ban amendment never saw the light of the day. Unfortunately, that is the story of Basel Convention. But the African Union, they went ahead and they came up with this Bamako Convention, which kind of absolutely banned any kind of hazardous waste disposal in their territories, and it also kind of criminalizes illegal trafficking of wastes. But this is something which is law in principle. But what exactly is happening in practice, that is a different story. Now, coming back to the national regime that we have, in fact, we have this umbrella legislation, as I've already mentioned. It's an overarching law. Then we have the Water Act of 1981, 1974, which in fact deals with several, if you remember, we discussed about pollutants, right? And there we have gone through these definitions with respect to air, with respect to water, sewage, and effluents and emissions in case of air, so on and so forth. These are the areas of several kind of discharge which in fact comes out from these industries, and these laws kind of dealt with it. However, this overarching law, so-called Environment Protection Act, in fact, it became an umbrella legislation for the protection of environment. It's a major with the impact that it had. It was something which we can also see from all these notifications and rules and regulations which were adopted from time to time to deal with several matters. And whatever I'm discussing, these are law in principle, of course. When it comes to law in practice, with the case laws and all, you come to know about all these things, of course. Once you deal with the case laws, you know that how state entities also kind of fail to perform their duties from time to time. So, with respect to the umbrella legislation that we have, this is something which the government authorities, they got the power from, the central government got the power from, and the hazardous waste management, something which also kind of came out of that umbrella legislation. As you all know, this is the act which empowers the central government under Section 3, subsection 1. And with respect to Section 3, subsection 2, clause 7, it exclusively deals with the central government being empowered by the Environment Protection Act to lay down procedures for handling hazardous substances. This has been specifically mentioned under Section 3, subsection 2, clause 7 of the Environment Protection Act. And at the same point of time, Section 6 of EPA deals with empowering the central government to lay down rules to regulate this environment pollution. So with respect to Section 3, subsection 1, Section 3, subsection 2, clause 7, and Section 6 of Environment Protection Act, we have the hazardous waste management rules. Now, with respect to these rules that we have in dealing hazardous waste management, it also came across several changes from time to time. In fact, if you go by several other hazardous related issues, you will find that prior to that there was something called hazardous microorganisms rules of 1993. Then there was I'll also come across I'll also discuss the manufacture, storage, import of hazardous chemicals rules of 1989. And you have this particular hazardous and other waste management and transboundary movements rules of 2016, which is the latest one. However, the first one was in fact the 1989 one, the rules which is the old rules. It was previously, because the latest one is the 2016 one, but the old one was hazardous waste management and handling rules of 1989. But the rules of 1989, it didn't cover these Basel conventions the salient features of Basel Convention. It didn't cover all those aspects which were covered under the Basel Convention of 1989 itself. And in fact, in order to implement the Basel Conventions, the 2016 rules were adopted. In fact, there were 24 rules which have been divided into 6 chapters, and 8 schedules are there. And as per this particular rule of, if you come across this 2016 rules, it in fact defines hazardous waste, which is quite akin to that of the 1989 rules. So as per that, this is what it is. In fact, the rules have been provided for ensuring that the quality of the air, water, soil all remains intact. And since, if you remember, one thing that you should always keep in mind, that when we do talk about waste management in our country, there are of course command and control approach which is there, which was also there under under the Water and Air Act. But similar kind of command and control approach has also been taken. But up lately, we have seen, especially after 2016, stringent measures have been taken by the central government from time to time. So it's the central government which has the power, and based on that power, it has established this particular rules, which in fact deals with procedures and safeguards for handling hazardous substances, prohibitions and restrictions on handling of hazardous substances, prohibition and restriction on location of the industries and carrying on certain process and operations in different areas, and also the procedures and safeguards for the prevention of accidents which may cause environmental pollution, for providing and also for providing remedial measures for the same. Now, this particular legislation that we've been talking about, the Environment Protection Act, in fact, it mandates a person who are responsible for discharge of any substances which is harmful to the environment, and if they discharge it in excess of the prescribed or specified limit, then they have to inform the authorities about it. And if they don't comply, of course, then of course the element of liability will be upon them, and they will be liable to clean up the polluter pays principle, if you remember, and mitigate any such damages which have been caused. And that is the reason the officers of the pollution control boards are especially empowered by the central government only. And as you have already studied under Water Act and Air Act, they have the power to enter the premises of any establishment, right? They can also go ahead and inspect any documents, take the samples. We have already discussed this under several laws, and this is something which also is related to waste management, of course. And you all know that if they fail to comply with the provision of the Environment Protection Act or any rules, so if someone violate the rules called the 2016 Hazardous Waste Management Rules, that individual is of course committing a criminal offense, which is of course violation of Section 15 of Environment Protection Act. It has been clearly specified under the same. The entire objective of the waste management is based on not just polluter pays principle, but also precautionary principle, right? Because we cannot also jeopardize our industrial development. Of course, this is something which also the Supreme Court from time to time has clearly identified. So you have to make a balance. And as you all know, which we have already discussed, and if you remember, I have already forwarded the Philip Sands book on international environmental law principle, you will come across this, and several case laws also, especially the Law Citizens Welfare Forum, where India kind of recognizes precautionary principles case. And from time to time, the court has held that the environmental measures by the state must anticipate, prevent, and attack the causes of environmental degradation. And where there is any kind of threats or irreversible damage, such actions should not be resorted to. This is the basic crux of the precautionary principle. And then comes the liability, because it is of course a liability, but the liability to prove that the action is in question is environmentally sound rests upon the person who is so-called the project proponents, who wish to engage in the same. So this is something which I've already discussed, is the reiteration of the same. So, and of course you know that the 1987 Montreal Protocol to Vienna Convention on ozone depleting substances, or Rio Declaration of 92, and of course prior to that the World Charter of Nature, they have all recognized this particular principle. Once again, the polluter pays principle is very significant with respect to the waste management, and this principle aims to take the party responsible for producing pollution responsible for paying the damages which have been done to the nature and the environment. And it has been also been held by the Honorable Apex Court in the Law Citizens Forum's case that absolute liability for harm to environment extends not only to compensate the victims of pollution, but also the cost of restoring the environmental degradation. So it's not just you pay them for the damages that has been done and it's done. No, of course not. Now, emphasis has also been given on restoration and remediation of the environment. So remediation of the damaged environment is a part of the process, and as such, polluter is liable to pay the cost to the individual sufferers as well as the cost of reversing the damaged ecology. This was clearly held in the Fellow Citizens Forum's case by Honorable Apex Court. As you all know, the Shriram Fertilizers case, also known as the Oleum gas leak case, where the principle of absolute liability without any exceptions, right? The strict liability principle was adopted in this particular case without any exception, also known as the principle of absolute liability, where once again the Apex Court formulated this principle that where an enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of an accident in the operation of such hazardous or inherently dangerous activity resulting, for example, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accidents, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortious principle of strict liability, which you have already studied under in the case of Rylance versus Fletcher, right? I believe this is a repetition of what I have already discussed, but these principles are significant with respect to waste management. And as you know, as I've just mentioned, that the hazardous waste management and handling rules, which first came in the year 1989, of course, it came just a couple of years after the Bhopal gas tragedy. And this principle was also invoked after the Bhopal gas tragedy because whatever they have learned from the Union Carbide case, this principle of absolute liability, so-called Oleum gas leak case, was kind of very much clear about this particular principle. They adopted. They wanted to ensure very strict liability upon the industrial establishments, those who are engaged in kind of inherently dangerous activity or hazardous activity. No, the thing is that when it comes to this 1989 rules that I have already mentioned, it has been amended several times. So between 1989 and 2016, there was another one, another amendment which was also significant. That is the 2008 amendment. Most of this amendment are kind of significant in a way, but the latest one is the 2016. But 2008 amendment, I will just discuss about its features also. Now, the hazardous waste management, handling, and transboundary movement rules of 2008 is an amended version of the 1989 rules. And of course, it was, as I've already mentioned a while back, that the 1989 rules were not in conformity with the Basel Convention. However, the 2008 rules were also dealing with the transboundary movement, because the previous to the 1989, the title of that particular rules was Hazardous Waste Management and Handling Rules of 1989. However, the 2008 amendment, the title of that was Hazardous Waste Management, Handling, and Transboundary Movement Rules of 2008. So it clearly highlights the amendment, the conformity of the Indian rules with respect to Basel Convention, right? And this particular rules also laid down powers, duties, functions of various actors who are involved in that entire process of handling management of this waste, namely the waste generators or recyclers, disposers, pollution control boards, and government especially. Now, we should also keep this in mind when it comes to this waste management. Another principle which is kind of guided here, it's not a legal principle though, but it can be taken as one with respect to the rules and regulations that's been adopted. But the term that I'm using, it is not mentioned as a legal principle, that is cradle to grave. Now, this cradle to grave, I would rather use the term approach rather than principle. So this cradle to grave approach is something which is guiding the waste management law of our country and several other countries also. Now, the thing is that the idea is, from the term itself, it's quite self-explanatory. The responsibility of the originator of a waste not only just goes away once that originator gives that particular waste to the recycler or disposer. No, not at all. His or liability, his responsibility, or her liability or her responsibility continues to that final stage of the waste disposal. He has to, or she has to ensure, or that entity has to ensure, that the particular waste has been disposed of in an environmentally sound manner. So they cannot just away with their responsibilities just by giving it to the transporter. Their responsibility continues. That is what is known as cradle to grave approach. Keep that in mind. Now, the entities upon whom this particular rules apply include several individuals, right? Now, with respect to that, this apply to all the substances that are defined as hazardous wastes, and it has been taken as a very inclusive approach. And here, if you go for the definition of hazardous wastes, this is something which they have defined in 2008, that any waste which by reason of any of the physical, chemical, reactive, toxic, flammable, explosive, Corrosive characteristics causes danger or is likely to cause danger to health or environment, whether alone or when in contact with other wastes or substances is hazardous, right? This is what Rule 3, Clause L says. However, if you refer to the 2016 Hazardous and Other Waste Management and Transboundary Movement Rules, this is the title, Hazardous and Other Waste Management and Transboundary Movements Rules of 2016, under Rule 3, Clause Subrule 17, Rule 3, Subrule 17, hazardous waste has been defined as any waste which has been kind of reiteration of this by reason of any physical, chemical, or biological. In fact, this biological term was not there previously, but now they have added biological, reactive, toxic, flammable, explosive, or corrosive, causes danger or likely to cause danger to health or environment, whether alone or in contact with other wastes or substances, and shall include waste specified under Schedule 1, Column 3, then wastes which have equal to or more than concentration limits specified under the constituents in Class A and Class B of Schedule 2, or any of the characteristics that has been specified under Class C of Schedule 2, and waste that has been specified in Part A of Schedule 3 with respect to import or export of such waste, or waste that has not been specified if under Part A must exhibit hazardous characteristics specified in Part C of Schedule 3. Now, here is the thing. If you have to, just refer to this rules once, you will come across the schedules and the parts, and there you will find a list of several kind of wastes. So this is just a technical part, but the major part is the first part. The rest is the inclusive one. And here the only change that I could find is that the 2008 rules, there was no term called biological in the chemical properties. Sorry, not chemical property. In the properties of the also called the characteristics of the waste. But in the 2016, they added, along with physical, chemical, reactive, toxic, flammable, explosive, and corrosive, they have added biological as well. If I'm not wrong, this is what I have observed. Now, this is with respect to the definition of hazardous wastes under the waste management rules of 2008 and 2016, respectively. Now, when it comes to the duty, so-called the liability, who owes the duty of care? Of course, the occupier of the premises. So the first instance itself, that individual or that entity is responsible, and in relation to that particular factory or premises, means any individual who has a control over the affairs of the factory. This definition is quite similar to that of that which we have already studied under the Water Act and Air Act, right? So occupier basically is the individual or the entity who is, as you all know, who is in control of the affairs of the factory or the premises, but also the management, if you remember, right? That individual is responsible for safe and environmentally sound handling of hazardous wastes. He is also responsible for sending and selling them to recyclers and to ensure that they are finally disposed of in a proper facility which has been authorized by the rules, and of course to transport them from, according to the waste management rules from time to time. Along with that, they also have a responsibility to give specific information which is required by the state pollution control boards from time to time, right? To take all adequate measures or steps to contain contamination, prevent accidents, to provide workmen training, capacity building related, and other aspects or other concepts which is associated with capacity building is also there. Now, the other concept that has been used as an operator, which means a person who owns and operates a facility for collection, reception, treatment, storage, disposal of the hazardous waste. This is something which has also been used under the same legislation. And when it comes to hazardous waste, if you refer to the 2016, they have identified industrial wastes. They have identified several other forms of hazardous constituents which have been categorized into these classes, which has been provided under Schedule 2. In fact, Schedule 1 of the rules also provide a list of several processes generating hazardous waste. That has been clearly mentioned under the same, and this is something where you will also find the role of the occupier is coming in. There are certain duties also with respect to the occupier, and certain powers are also there with respect to the state pollution control board. So if any person who is involved in generation, processing, treatment, package, storage, transportation, use, collection, destruction, conversion, and even for offering for sale, transfer, or like of hazardous waste shall do any of those acts after obtaining a prior permission from the state pollution control board. This is a control mechanism, and that is something which is very much important, and that's the reason this authorization for handling the hazardous waste management is required under rule 4. And the person who is engaged in these activities, they have to apply for authorization in a prescribed form, and the limitation period is 60 days. So within 60 days they have to apply from the date of the publication of that particular rules itself. And here the state pollution control board is in fact bound to either grant or refuse within a period of 120 days for such authorization after making necessary inquiry which is required, and that shall be valid for a period of 5 years. Keep that in mind. And in case of refusal, the applicant should also be given an opportunity to being heard. It's natural justice principle, right? And that reasons for the refusal shall also be given to him in writing. And in case the holder of the authorization in fact fails to comply with the conditions that has been put forward or have been put forward by the state pollution control board, the pollution control board can cancel or even suspend the authorization after giving an opportunity of being heard and after recording the reasons for the same. And once it is cancelled or upon suspension or cancellation of such grant, the person who's concerned here will be required to keep the storage of the residue hazardous waste safe. This is something which also the law clearly envisages. So this is what it is. I have already mentioned about these things, so keep that in mind. 120 days limitation period, 60 days for application, and 160 days for granting or refusing. 5 years is the validity. Prescribed form is already there. SPCB can also deny the permission. If you fail to comply, they can also do the same. Please refer to Rule 6 of the hazardous waste management rules. Now, storage is something which is again quite important as regards the same. And before I get into that, you should also keep this in mind that every occupier who is authorized who has been authorized by the State Pollution Control Board shall maintain a record of the hazardous wastes which he or she is handling under in accordance to this format which has been prescribed in the rules itself. That's Form 3. And with respect to Form 4, they have to also file an annual return containing all the details with respect to the hazardous waste that they're dealing with. When it comes to storage of the hazardous waste, not just the occupiers but also the recyclers, reprocessors, reusers, operators of facilities may store the hazardous waste, but the limitation period that they have specified is 90 days. That has been specified under Rule 7. And they also should all maintain a record of sale, transfer, storage, recycling, reprocessing of such hazardous waste, and such record should be made available for inspection by the State Pollution Control Board. The limitation period that has been specified as 90 days, but that can be extended by the State Pollution Control Board in certain circumstances, in case of small generators or in case of recyclers, reprocessor, or facility operators. Up to 6 months it can be done, but it is upon the State Pollution Control Board to determine. It is not a straitjacket rule. It's in fact it can be extended, but it is based on their inspection and it's their discretion to do so. When it comes to recycling, reprocessing, and reusing of hazardous waste, there is a process and there is something called registration and other duties which are also associated for the same. Now, if an individual who wants to recycle or reprocess the waste, they have to refer to Schedule 4 of the hazardous waste rules, and they need to apply in Form 5 along with the required documents. Now, if the Pollution Control Board is satisfied with everything which the applicant is putting forward, if they are satisfied that yes, the applicant has the capability as well as the technology to recycle the particular hazardous waste, only then they can grant the authorization along with such conditions which it is required. So there will be the grant, but the State Pollution Control Board can also and give certain conditions associated with it. I don't know, is it the topic which is making the dog barking repeatedly? I think waste is something which no one likes, but you have to handle it in an environmentally sound way, because we are the one who generates and we are the one who also don't like waste lying around here and there, right? So the entire thing of recycling and reprocessing or even reusing of hazardous waste is something which has also been covered under the hazardous waste management rules of our country. Now, in any case, an application for which is kind of that is complete in all the respects, be disposed of within 120 days from which it is received. So 120 days is something which they have specified. And authorization, once again, Even for recycle and reuse, it is for 5 years. That's the validity period that has been specified under Rule 8. So, along with that, all these things are kind of going in accordance to what we have seen in the case of occupier. It's kind of going in the same kind of a track. So, the recycler and the reprocessor, they have to also maintain record, they have to file returns according to the forms that have been prescribed. The occupier, whoever generates hazardous waste, which is specified under Schedule 4, may also sell it to only to the recycler having a valid registration from the Central Pollution Control Board for recycling or recovery. That has also been mentioned that with respect to certain waste which is specified under Schedule 4, the occupier may sell it only to the recycler having a valid registration from Central Pollution Control Board for recycling and so here CPCB also comes into play. Please do refer to Rule 9 for the same. When it comes to import and export of hazardous waste, which in fact was not there initially in the 1989 rules, but because of Basel Convention, we ratified it, and the Ministry of Environment, Forest and Climate Change is the nodal ministry to deal with the transboundary movement of hazardous waste and to grant permission for transit of all these hazardous waste from time to time. That has been specified under Rule 12. In fact, no imports of waste into India for its disposal is permitted, but still it is going on, unfortunately. Illegally, it's happening. It's been happening for quite a long time because many a times they just get the prior informed consent without disclosing proper information about it. Many a times these ships which comes down, those shipwrecking industries, shipwrecking ports, and they are not even aware that that ship is carrying certain hazardous waste in the barrels and also without even realizing about it. These are the things which are happening in very ugly way. If you just watch any documentary, because environmental documentary is a very good source of information, I do refer to them because I cannot travel everywhere and then see what is happening all around. Because of these documentaries, it kind of becomes an eye opener for all of us. So I draw my inspiration from many of such documentaries. You can also watch the same. So imports or export of waste, which is mentioned in Schedule 4, is absolutely prohibited. Hazardous waste may be exported from India to an actual user of the waste, the operator of a disposal facilities. And as I mentioned, PIC, so-called prior informed consent, is required of the importing country to ensure that the environmentally sound management of exported waste is required. So they should also kind of render all sorts of assistance, but unfortunately, it doesn't happen in real life, unfortunately. Exporting hazardous waste has also been considered, and for exporting any hazardous waste which is specified in the Schedule 3, an application has to be made. In this case, it has to be made to the central government, and the time specifically mentioned here is 60 days, and they should get the no objection certificate for the same. And once you get the NOC, that NOC will be forwarded to CPCB or even the concerned and the concerned SPCB, so-called the State Pollution Control Board, and other ports and custom authorities who are involved in that process. Now, the shipment should be accompanied by the proper document which has been which should be in accordance with Form 9 of the rules, and the exporter shall inform the Ministry of Environment, Forest and Climate Change upon completion of the transboundary waste movement. And it is a duty of the exporter to maintain the records of all this hazardous waste exported by him in Form 10, and that should be also available for inspection by the government, by the authorities empowered by the government. When it comes to import and transit of the, because export, import, and there is also state of transit which usually comes in between. So for that also we have a prescribed format under Form 7 and Form 8, and a copy of application shall also be simultaneously be sent to the concerned State Pollution Control Board for the same. The time period that they have specified is 60 days from the receipt of the application. Within the 60 days, the ministry will grant or refuse the permission, and a copy of that permission shall be also forwarded to the CPCB and SPCB and Customs and Ports authorities. And this movement document, which has been specified under Form 9, and test report analysis of the hazardous waste consignment which you are exporting, all these things should be part and parcel of it, and it should be also approved by the Director General of Foreign Trade. The DGFT will also authorize the same, and the Custom Authority shall also collect 3 randomly drawn samples for the consignment for the records and for analysis. Now, the importer of the hazardous waste, they should also maintain a record of the hazardous waste imported to him, and that for that is Form 10, and they have to maintain a record for the same. And the importer shall also import the concerned State Pollution Control Board and Central Pollution Control Board within 10 days in advance the date and the time of the arrival of the consignment. And export, import, whatever is carried out without all these compliance is highly, and even if you're doing it by misrepresentation and fraud, then it is illegal, deemed to be illegal. Even deliberate dumping is deemed to be illegal. So, in case of illegal import, the importer is to re-export the imported waste within 90 days. So, if it has been illegally imported, then it will be sent back to the exporter. So, re-export will be done according to Rule 17. With respect to transport, that was the thing. But even for treatment, storage, and disposal, which is a major challenge, the hazardous waste management rules deals with the same. And here, the state government, occupier, operator of facility, association of the occupier, they are individually and jointly, in fact, several times, severally liable for the same. And they have to identify the sites for establishing the facility of treatment, storage, or disposal sites. The operator shall design and set up the treatment, storage, and disposal facility as per the technical guideline which has been provided by the Central Pollution Control Board, issued by the Central Pollution Control Board. Such guidelines should be prepared from time to time. It should be very much dynamic at the same point of time, and they have to get the approval. The operator, they should also obtain the approval from the State Pollution Control Board for design and layout of that entire thing. The State Pollution Control Board is also responsible to monitor, the setting up and the operation of treatment, storage, disposal facility of the hazardous waste, and the operator of the treatment, storage, disposal facility of the hazardous waste is also responsible for environmentally sound operation and closure in accordance with the guidelines which has been issued already. Of course, it's there by CPCB and central government from time to time. When it comes to transport, when it comes to all this entire process, packaging and labeling is something very important. Otherwise, it will spread over, right, if it is not properly packaged and labeled. And the individual should also know what kind of waste that they are carrying. So labeling must be easily visible, and it must withstand physical and climatic condition. The transport and the labeling is also covered by rules which the central government has adopted. You are aware of it, the Motor Vehicles Act and the Motor Vehicle Rules, right? The occupier shall also provide the transporter with relevant information in as per Form 11 with respect to the hazardous wastes, and whatever measure that has to be taken in case of emergency, that is something which is there. And if there's this mark also hazardous, you know about it, right? So that mark should also be there. And in case of transport of all those wastes which are there for treatment, storage, and disposal facilities in different states, the NOCs from all the PCBs is to be acquired. This is a very tough thing, all technicalities thing. So one who is engaged in this process, well, if you go by the law, then they have to cover a lot, right? So maybe because of that, many a times they don't. So that's other story. So in case of movement through any other state other than that of origin or destination, the occupier is to inform the concerned state pollution control board before the waste is handed over to that particular transporter. So they see the responsibility continues. The cradle to grave approach continues even for packaging, labeling, and transport of the hazardous wastes. With respect to this, please do refer to Rule 21, which provides for a manifest system for all the movements within our country. The occupier shall prepare 6 copies of this manifest. In Form 13, it has been prescribed, which comprises of color code. It's been indicated. There are 6 copies that has to be signed by the transporter, and transporter has to no transporter is going to accept if it's not there with the proper manifest. So that is there. There are other duties of the occupier and operator also. The occupier who is generating hazardous waste, or even the operator of a particular treatment, storage, and disposal facility, they shall maintain records of such operations, and they have to also file annual returns to the State Pollution Control Board according to Form 4. And if unfortunately any accident occurs in any facility or an hazardous waste site, or during transportation of any hazardous waste, the occupier or the importer of that particular facility or the transporter, as the case may be, shall report immediately to the State Pollution Control Board. So they should not suppress it, they should rather inform. Maybe what happens is that because of the liability factor, they usually don't. But as per the law, they are supposed to inform the State Pollution Control Board about that particular accident in a proper format, so-called Form 14 of the rules. When it comes to the State Pollution Control Board, the government, they also have certain liabilities, and powers at the same point of time. So they are responsible for preparing inventory of hazardous wastes within their jurisdiction, right? It might not be there that all kind of SPCBs are dealing with all forms of hazardous waste. It kind of varies from what kind of industries they have within their jurisdiction. So they have to prepare an inventory of all this hazardous waste related information that comes within their jurisdiction. They should compile other related information like recycling the hazardous waste or treatment disposal facility, whatever is there. So based on the returns and information which are usually filed by the respective occupier and operator, they have to prepare this. They have to compile all this information. The occupier, importer, transporter, and operator of all these facilities, they also have a liability. They are liable. They shall be liable for all the damages which is caused to the environment or third party due to improper handling of the hazardous wastes. The occupier operator of the facility shall be also liable to pay financial penalties as levied for any violation with respect to any provision under these rules by the State Pollution Control Board with prior approval of CPCB. So that is something which has also been mentioned under the hazardous waste management rules. The provision of appeal is also there. So, if any person who is aggrieved by an order of suspension or cancellation or refusal or authorization or renewal passed by the State Pollution Control Board, they can file an appeal in Form 15 to Appellate Authority, which usually comprises of the Environment Secretary of that particular state, and that has to be done within 30 days from the date of such order, which has been communicated to that individual. Any person who is aggrieved by an order of suspension or cancellation or refusal of authorization or even renewal passed by the Central Pollution Control Board, they have to apply to the appellate authority, which comprises of the Secretary's Government of India. So the form is same, but if it's with respect to CPCB, Central Government Secretary, with respect to Ministry of Environment Forest, within 30 days, and if it's with respect to state, SPCB, then to the Environment Secretary of that particular state. Now, the appellate authority, they can entertain the appeal with the expiry of 30 days if it is satisfied that the appellant may be prevented by sufficient cause for filing the appeal in the same. This is a procedural thing, and every appeal filed under this rule shall be disposed of within a period of 60 days from the time date of filing. So 60 days is the limitation time, and this is the time period within which they have to decide and dispose of the matter. Even the transporters, they have certain responsibilities under the waste management rules. They have the procedure of registration. So each and every transporter must be, who are dealing with hazardous waste, they must be registered with the Department of Transport and Department of Environment and Forest of the respective state. They have to take permission from SPCB. They have to maintain a manifest system. They have to train their drivers and helpers because they are not dealing with normal kind of waste. They are dealing with hazardous waste. So they should be properly trained and well informed about it, how to deal with, how to handle it. The transportation of hazardous waste must be done in a specified vehicle, not any kind of vehicle. The waste must be transported in closed containers all the times. It should not be open and it should not kind of spread all the things around. And the waste must be delivered at the designated points. In case of emergency situation during transportation like spillage, leakage, or accidents, the SPCB and other regulatory authorities must be informed immediately, which is there for the accidents also. And in case of contamination, the transporter is liable to ensure a proper cleanup. These are the responsibilities of the State Pollution Control Board. As you can see on the left side, to grant, refuse, or cancel hazardous waste authorization. They are also responsible to prepare inventory of hazardous waste generating units and quantum of hazardous waste generation. They should also monitor the hazardous waste which is being generated by their units within their jurisdiction for ensuring safe storage, treatment and disposal of waste. They should also ensure re-export of illegally imported hazardous waste. At the same point of time, they should also grant registration to the traders for import of hazardous waste. They should analyze the waste characteristics in order to decide its nature. They are liable. They are responsible to not liable, responsible to monitor the setting up and operation of the treatments, storage, disposal facilities of hazardous waste. And finally, they should also regulate the import of hazardous waste as per Schedule 3 of the hazardous waste rules. With respect to the responsibilities of the occupier, you have these are the responsibilities. They have to obtain hazardous waste authorization. They have to obtain for recycler also. There's something which is there. They have to obtain for CPCB in case of utilization of hazardous waste. They have to submit annual reports from time to time by 30th June of every year. They have to dispose their hazardous waste on their own or through a proper recognized treatment, storage, disposal facility. They should maintain a manifest system as prescribed in the Form 13 for waste transport and disposal. They should store hazardous waste in an environmentally sound manner. They should also report accidents as per Form 14, and they should also maintain a record of storage, sale, transfer, recycling, and reprocessing of hazardous waste in Form 3. Along with that, 1989 manufacture, storage, and import of hazardous chemical rules is quite significant. In fact, this rules shall apply to all the manufacture, storage, and import of chemicals that are hazardous. There are certain powers and functions which are also performed by these authorities, which has been mentioned in Schedule 5 of the same rules. There are also duties of occupiers and industries according to that particular 1989 rules, which clearly specified that the occupier of the industries, they should provide evidence to show that he has identified the major accident hazards and that he has taken steps to prevent such major accidents and limit its consequences on human beings and the environment. It is also duty of the occupier to inform the personnel working on site, train them, and provide them with safety equipments, antidotes, and to ensure the safety, which has been also been specified under Rule 4 of the 1989 rules. If a major accident occurs, then once again they have to notify. And this is something which is kind of quite similar, quite akin to that of the hazardous waste rules. With respect to application of the rules, with respect to the chemical rules of 1989, in case of certain industries, the industrial activities which they are involved in, if it involves a major quantity of hazardous chemical, which has been listed under the schedule of the same rules, then they have to take extra measure. And they should also have isolated storage, which should involve there should be kind of clarity over that, what kind of waste that they are generating, what kind of waste they are handling, and all these things have been mentioned, that they should have an isolated storage. They should have the quantity has been mentioned, prescribed. If you are engaged in that kind of activities, then what kind of responsibility you have to bear. The industrial activity which shall not be undertaken, which has been undertaken without getting proper authorization, that is also something which has been clearly held illegal. In fact, industrial activity shall not be undertaken unless that the occupier has submitted a written report to the concerned authority containing the particulars of all those things that he or she is dealing with, and that has to be done according to the format which is specified in Schedule 7 of the Chemical Rules 1989 within 3 months from the commencing of that particular activity. When it comes to Rule 10 to Rule 12 of the chemical rules, the occupier is not to undertake any industrial activity unless he has prepared a safety report, not safely report, safety report on that activity. The report must contain all the information that has been specified under the chemical rules. The report has to be sent to the prescribed authority, and the occupier is not to make any material changes in the activity covered by the report. And if he intends to do so, a further report shall be made with all the modifications proposed to be made, and it should be sent to the competent authority within 90 days for the same. There are also certain emergency plans and actions prepared envisaged under the chemical rules of 1989. The occupier is required to prepare and keep an on-site emergency plan detailing how major the accidents will be dealt with. The plan must carry the names of the person who are authorized to take actions. Every person on the site who is affected by the plan is to be made aware of the provisions of the plan. The plan has to be prepared before the activity. This is a preventive measure that they have kept in mind when they drafted these rules. And in case of any existing industries, the time period that they have specified is within 90 days. And the occupier is to take the steps to inform the person who are residing outside that particular site, either directly or through district emergency authority who's likely to be. So here what happens is that during certain accidents, usually what happens is that it just doesn't remain confined within the industrial unit. It also goes beyond that, right? And here, the responsibility lies upon the occupier to also involve those people who are residing in the vicinity. And this is something which you will also come across. There's something called Public Liability Insurance Act, which was basically about those individuals who are working in a particular industry, and if something goes wrong, then whether some sort of indemnification is there with upon the so-called the occupier of that particular industrial establishment. Now, with respect to collection, development, and dissemination of information, an occupier is also responsible under the given chemical rules to obtain all this information and develop a proper information system and maintain a form accordingly, which has been specified under Schedule 9 of the chemical rules, and keep it, because this information can be accessed and inspected from time to time by the State Pollution Control Board and prescribed authority. So the information shall be accessible upon request for reference. An occupier has to ensure that the information is recorded correctly, and it should reflect the scientific evidence used in making the hazardous determination. So every container of these hazardous chemicals which have been kind of handled needs to be marked to identify the content of the container, the name and the address of the manufacturer, as well as the importer. And with respect to the feature or the characteristics, the chemical, physical, and toxicological data should also be accompanied or annexed with that particular information. So dissemination of information, for that you need to have collect you need to collect that information in the first place and develop accordingly from time to time. Even for imports of hazardous wastes, if any individual who is importing chemical wastes, hazardous chemicals, they have to provide informations, and this information will be, of course, the name and the address of that individual who is receiving the consignment in India, the ports of entry in India, the mode of transport, the quantity of the chemical that is imported, complete product safety information, also all these things should be accompanied. So the liability is upon the importer to get all these informations from the exporter in the very first place, right? So, and that importer is also kind of entitled to get this information from exporter only on the basis of those informations which the exporter provides. The importer is supposed to give the prior informed consent, right? So these informations will again be required by our national focal point, so-called our prescribed authority, and that is the reason because of which the person who is importing will be again responsible and liable for the same. So that has to be submitted to the concerned authorities according to the format which has been prescribed under column 2 of Schedule 5, and the time period that they have specified is within 30 days from the date of import. And any person who is importing hazardous waste chemicals shall maintain records of the hazardous chemicals that they are importing, and this record shall also be open for inspection by the concerned authority. That has been clearly specified under Rule 18 of the chemicals rules. There are certain powers and duties of the authorities also at the same point of time. Once you receive the report as an authority, you can also ask for additional information to the occupier, and occupier is bound to provide all that additional information from time to time. The concerned authority shall also undertake a full analysis of major accident and send the requisite information to the Ministry of Environment, Forest and Climate Change through appropriate channel. It should also prepare and keep itself up to date with all the adequate off-site emergency plan detailing how emergency related to a possible major accidents or on that particular site be dealt with. It should also, at the same point of time, to enable the authority to prepare such emergency plan. The occupier is also bound to assist and inform and provide all the necessary information relating to the activity as is requested by the authority from time to time, and any other information which in fact includes the nature, the extent and the likelihood of its side effects and the offsites on the possible major accidents. This have to be shared with the prescribed authority, and the prescribed authority should keep all these informations and should also forward it to the proper ministry if so required from time to time. So the authority needs to prepare this plan before the activity commences, and on receipt of any information relating to import of hazardous chemicals, the concerned authority of the state should be well aware of what the particular occupier or importer is importing, and it should be also satisfied that chemical which has been imported is not likely to cause any major accident. They have to ensure that And if they are importing anything which might have the likelihood to cause, then the importer is taking all the reasonable steps to ensure that accident can be avoided. So this is something which has to be also ensured by the prescribed authorities, and that's the reason the authority can also ask the port authority to take appropriate steps regarding the safe handling and the storage of the hazardous chemicals while offloading the consignment. And if the concerned authority is of the opinion that the person has contravened the or violated the provisions of these rules, the concerned authority shall serve on him a notice requiring the person to remedy the contravention on the or the matters that has caused the particular contravention within a specific time period as mentioned in the notice. So this is what the prescribed authority has also entitled to, not entitled, sorry, prescribed authority is also empowered, and it's a duty upon the prescribed authority to ensure the implementation of the chemical rules of 1989 dealing with hazardous waste or hazardous chemicals to be very specific. So this is what we have, for hazardous wastes in our country and hazardous chemicals. So please do refer to the 1989 hazardous waste management and handling rules and 2008 hazardous waste management and transport of hazardous waste in fact management rules, and then 2016 hazardous waste management and transboundary movement rules. So that is with respect to hazardous waste. The first one was hazardous waste management and handling rules of 1989. Then came the hazardous and other waste management and transboundary movement rules of 2008, and then again hazardous waste and other waste management and transboundary movement rules 2016. And with respect to hazardous chemicals, the manufacture, storage, and imports of hazardous chemicals rules of 1989. So I insist, please do refer to these rules and go through it. And in order to have some better understanding about, please do refer to the schedule and the forms also, which has kind of specified. There are n number of that. I understand it's pretty lengthy, but it's worth reading. Maybe you should be aware of that also. Just have a look at those schedules and the forms just for your knowledge. So this is all for hazardous waste management, and in the next lecture I'll discuss some other facet of environmental law. So maybe waste management. Of course, waste management, I have few more lectures also on waste management, and then I'll get into climate change, so or maybe some other areas. So until then, you take care of yourself, take care of your family, stay home, stay safe. Thank you very much.